Ready? Start. Now, the question that begs consideration in the light of the submissions advanced across the bar is whether the principles of natural justice were observed in compliance or not. Stop. As stated herein above, Rule 81 of Rule 1976 does prescribe observance of the principles of natural justice. Stop. From a close scrutiny of the inquiry report dated 29/10/1993, it transpires that the inquiry officer has found the petitioner guilty on the basis of the reply to the charge sheet submitted by the petitioner and other documents, but not a single witness was examined by the inquiry officer in the presence of the petitioner, and also no date, time, and place was fixed by the inquiry officer. Stop. It is not discernible from the inquiry report that the petitioner was never granted any opportunity of personal hearing or cross examine the witnesses, and in the circumstances there appears to be non compliance of regulation 81 bracket A of the 1976 rules, which enjoins due observance of the principles of natural justice. Stop. In this connection, Article 14 of the Constitution of India may also be referred, which clearly postulates that authority competent to pass orders for is required to record reasons, which is one of the principles of natural justice governing exercise of power by the administrative authority. Stop. It is well enunciated in various decisions of the High Court and the Apex Court that the disciplinary authority has to apply his mind to the record apart from the finding recorded by the inquiry officer before coming to the conclusion whether the charge of misconduct has been proved against the delinquent. Stop. Para. Merely asking the petitioner to submit an explanation, in my opinion, stop, is not sufficient where it is proposed to impose a major punishment. Stop. There are two kinds of hearings: a personal hearing and second, non-personal hearing. Stop. When it is proposed to impose a minor punishment such as withholding of increments or a fine or warning, a non-personal hearing would suffice. Stop. In a non-personal hearing, all that has been done is that the delinquent employee is issued a show cause notice to which he gives a written reply, and on that reply the punishment is straightway imposed, giving reasons. Stop. In such a case, it is not necessary to hold a full-fledged oral inquiry, giving the concerned employee an opportunity of producing his witnesses and cross-examining the witnesses against him. Stop. However, when it is proposed to impose a major punishment like dismissal, ordinarily a full-fledged inquiry must be held. Stop. Over.